Looks as if we have one case for argument today, McDonald versus State. Ms. Cohen.
Good morning, and I would like to reserve 3 minutes for rebuttal. May it please the Court? My name is Susan Cohen, and I'm appearing on behalf of Rebecca McDonald, the petitioner in this matter. This case is before the Court for certiorari review, and it is our position that the Circuit Court, as well as the County Court, failed to properly apply the procedural rule, Florida Rule Criminal Procedure 3.850, as interpreted by the District Courts of Appeal as well as the Supreme Court, and that the Circuit Court failed to apply the correct standard of review when reviewing the decision of the County Court. This case arose in the County Court as a...
I'm sorry, what was the incorrect standard that the Circuit Court applied?
In this case, it's our position that the Circuit Court, one, failed to apply the law as it has been, the rule as it has been interpreted by the case law. Well,
let's start with what standard did it apply?
It also reweighed the facts, in that the Court clearly found that the County Court opinion was substantively incorrect because it relied on the Tipsy-Coachman doctrine, pointing out its ability to render an opinion affirming the County Court if it reached the right reason for the right result for the wrong reason, thereby apparently recognizing the error of the County Court in its substantive determination.
But there's no serious argument in this case that your motion was untimely, is there?
We do not believe that there is a serious argument that it's untimely under the interpretation.
I mean that your motion was untimely.
It was untimely as far as the 2 years, but it fit within the requirements of 3.850 of it being newly discovered by Ms. McDonald. Newly discovered
that counsel did not file a motion to suppress?
Your Honor,
do you know what that would do to the dockets of the courts of appeal in this state?
We recognize that, Your Honor. However, in this case...
No, really. Do you know what that would do if your argument, and your argument's fairly clear, I commend you for that, but your argument is simply that counsel did not provide adequate representation because before I believe a plea was entered in this case,
yes, sir,
he or she did not file a motion to dismiss. You've not alleged a motion to suppress. You've not alleged a new witness. You've not alleged an unanticipated change in the law. This would bring down the courts of appeal in the state.
However, this case is different than others, and we have addressed this issue in other cases. What's unusual about this particular case is that there are very specific issues that she became aware of that were contained in documents that were available to her attorney, which would have completely...
There's a remedy there, though, counsel, but it's not 3850.
Once she has... the case is over within the 2 years, and because she's entered a plea, then that is her only remedy.
The remedy is an action for malpractice, but the burden of proof is very different.
In a criminal proceeding, that does not provide her anything, because the result is a conviction based upon an involuntary plea based upon the failure of counsel to adequately represent her. And this is a very clear example.
You haven't said anything at all about why this case is different from every other plea case or a trial case where counsel does not file a motion pre-trial based on facts that were known at the time.
Because this is very specific, because the facts underlying the grounds for the motion were, number one, were not known to Ms. McDonald.
They don't have to be for purposes of 3850.
But this is a 3.850 alleging ineffective assistance of counsel. So when you're alleging ineffective assistance of counsel, the client is not, and we've cited the cases in our brief, charged with constructive knowledge of the knowledge of their counsel. And in this case, the only evidence at all against this young lady was the blood test result. That is the only
But wouldn't this argument do away with the 2-year limit for all ineffective assistance of counsel claims? You'd always be able to come in and make this argument 4 years later, well, my lawyer should have known to do this. I didn't know it. I'm not a lawyer. My lawyer should have known to do it, but because I didn't know it, I'm excused from the 2 years.
Well, the difference in this case is that she did not know, and her testimony, uncontroverted testimony, was that she was not aware of the information contained in these documents, and obviously along with that, the legal implications.
That's every criminal case. That's what we're trying to suggest to you.
However, in most criminal cases, it doesn't have this impact, the impact that it would have in this case, and
counsel,
as has been recognized.
There are 3850 cases where there were witnesses known to counsel who were not known to the client, and that doesn't allow you a departure from the 2-year requirement.
The thing that separates this case from the other cases and puts it in line with some of the cases that we cited as far as timing is this is something that would have There is no question but that had there been a motion to suppress it, had he discussed that with her, had he explained that to her, had he made her aware that the blood was obtained illegally from her, that she would not have entered a plea. This is not a case of where there was all this other evidence. This is not
I thought she consented to the
Well, the document
search.
it lists two things. First of all, in a motion to suppress, it would be the state's burden, and the cases are very clear that because we have implied consent, if you are going to take blood voluntarily, you have to explain, one, that implied consent doesn't apply, and that it also, if you read that once you read implied consent, and the consent is out the window, and two, that you have to advise them that the implied consent does not apply. In this case, the evidence that the attorney ignored was, one, the office, aside from the fact that the officer illegally obtained her medical records, so it would not have been admissible under, okay, if we lose the blood, we can go back and get the hospital blood. So that would not have been admissible based on the evidence that would have been before the attorney. The other thing is that he also indicated on that very same document.
Is that newly discovered evidence? Is that newly discovered evidence, or is it a newly discovered argument?
It's a
I mean, see, I always thought newly discovered evidence meant some evidence that pertained to the issue of guilt or innocence, which was recently disclosed, recently came into the knowledge of a party. And here it seems to me you're using this to mean some argument that your client just realized could have been made. Not really evidence, is it? I mean,
except that it's her recognition, her newly discovered recognition of these documents and what they contain, coupled with the legal implications. In the cases that we have cited, some of them that were within the 2 years where the courts have found that sufficient for ineffective assistance of counsel because the defendant did not know or was told they had no defenses. In some of the cases that we've cited, it is, in fact, police report statements. One of them relates to even a document that counsel himself requested regarding the wife that could have led to support for the defendant's argument that this was a lewd case where his contention was that the witnesses made it up, that his wife put him up to it, and this was a document that his own attorney had created, and yet he was not aware of it. The other decisions that we've also cited, some of them have to do with sentencing, but some of them have to do with misadvice regarding collateral consequences. Clearly, that has nothing to do with guilt or innocence. The withhold of adjudication.
This is not a misadvice case.
Well, it is to the extent that he told her this was the best thing she could do, and he did not tell her that there was.
Is there any misadvice as to collateral consequences case that is treated as newly discovered evidence in the sense that it can be done more than 2 years?
Yes, sir, and we have cited those cases, the Rodriguez case, the Johnson case, the Morales case. In each of those cases, they've discovered one, the Johnson case, he was a correctional officer. He was told that withhold of adjudication would not affect his ability to be a correctional officer. Clearly a collateral consequence. And over 2 years later, he was advised that his certification was being revoked. Morales, also withhold of adjudication, applied for to be a vehicle recovery agent, was told no because you entered this plea. Clearly a collateral consequence. The Rodriguez case wanted to be a bondsman, and 6, 7, 8 years was told he could not do so. In that case, the court remanded it back because he didn't allege, specifically noting he didn't allege when he found out that even though it's not a conviction, but that plea was going to impact. So those three very specifically.
But those have to do with the voluntariness of a plea, right?
And that's what this.
Well, your case is ineffectiveness in failing to file a motion to suppress.
Which resulted in an involuntary plea, which is the standard on a ineffective assistance of counsel on a plea, because the second prong is the prejudice is you would not have entered a plea. It's all wrapped up in the voluntariness of the plea, which is what the language that this court used in the Thompson decision in talking about the question being the impact on the volitional nature of the plea. This is a case where you have an 18-year-old who was clearly not at fault in the accident because the witness.
None of that's relevant, counsel.
And there's no question
about it. It's not a jury.
None
of that's relevant. I mean, I'm back to the first question I asked and the first question Judge Padovano asked, which is, I cannot, this court, you may not be aware of this, I know what your practice is. We hear 1,000 Rule 3s every year in this court. And the district courts of appeal in the state's about 3,500 or so every year. I'm going to suggest to you that if your argument prevailed, there would be no time limitation.
And, Your Honor.
Because anybody that files after 2 years, ipso facto, is claiming they didn't know it before 2 years, or they wouldn't have filed after 2 years.
And that's not necessarily, with all due respect, that's not necessarily so, because some people did. And we have had cases where they knew all along, they just either thought they couldn't do anything about it, or they
Yeah,
didn't
but your
have the money to
argument-
do anything
Your
about it.
argument is that because you have somehow suggested misadvice or incompetence, and I'm not sure how you suggest that the attorney's knowledge is not attributed to your client, and that would set the whole system on its head. If the client had to know every material fact, every legal conclusion, there would be no client ever convicted after a guilty plea that couldn't bring a 3850.
And there are some cases, a couple out of the 2nd District Court of Appeal and one out of the 5th District Court of Appeal, the one out of the 5th being the one that I mentioned before, where the attorney himself had commissioned this report and his investigator had uncovered information regarding the defendant's wife. Also, the 2 out of the 2nd District Court that we've referred to, the Bailey decision and the Porter decision, each of those cases were witness statements that the police had, and they clearly said it could not be imputed, the knowledge could not be imputed to the defendant under those circumstances. And that is what we have here. These are
Well, I'm not as
specific
familiar with
facts.
those cases as you are, but I am familiar with the standard of new evidence, and that is which was not discovered or could not have reasonably been discovered at or before. And quite frankly, if you're representing those cases correctly, I don't see how they fit in that standard.
Because based under those decisions, and even the other misadvice, clearly in all of those cases, even the misadvice cases, has a defendant gone and gotten the information? It was clearly would have been there had they known, had they not relied on their attorney's advice.
What if counsel said in a hypothetical case, ma'am, we've got some grounds for a motion to suppress, but I think we'll lose on that. I advise you not file it.
Then that's different, because then they have the opportunity to consider it and to make that decision. This is what I believe we can file.
My question supposes, ma'am, though, that he didn't tell her what the grounds were. He just said, we've got some grounds, but my advice is that we not pursue that.
And I think it's going to be factually specific. And I think that's why I think it's not opening the floodgates, because this is factually specific. There are some cases where it's not sufficient, where the attorney did go through the information or the defendant was aware of the facts. But in this particular case, because of the nature of the facts and the nature of the documents that were later discovered, and it was documents in Bailey and Porter that were late, as well as Osborne, which would have provided impeachment in those cases, only impeachment. Whereas in this case, based on, as we've outlined in our motion, and realizing that that's not really the issue of whether she would have won on her motion to suppress, because the Supreme Court made it clear in Grosvenor that that's not the question. The question is, was there a viable defense that impacted their decision to enter a plea? And I see that my time is up, and I would like to, I'm into my rebuttal time.
Thank you. Stay.
Good morning, may it please the Court. Terry Roberts for the State of Florida. Well, it seems like the Court has a decent handle on our position and our view of the case. There's not too much to add to some of the substantive discussion of what the Circuit Court had to consider, but I think it's proper to keep the focus on something that wasn't mentioned in the initial part of the argument here, which is certiorari. Judge Connie, you pointed out that the Rule 3.850 practice in this Court would dramatically increase if the only standard for proving newly discovered evidence was, I hadn't thought of this legal argument until now, or my new lawyer told me that this new legal argument was available. And that, of course, would be a danger and would result in the flood that you were discussing. But I think this Court should also be mindful of the danger of opening floodgates of certiorari petitions, because what we're supposed to be considering here in the petition for certiorari is whether the Circuit Court departed from the essential requirements of law. And Judge Benton, you asked the question about what standard of review was improperly applied here. The Circuit Court discussed...
Her answer was that the Circuit Court improperly engaged in fact-finding. What do you say to that?
Well, I say that there's no basis for that. Almost every appellate opinion that this Court puts out, at least every written opinion that's not a PCA, has some sort of discussion of facts. That doesn't mean that this Court is fact-finding. It's just stating facts that are in the record. The Circuit Court discussed the timeliness argument, and then in an order denying the motion for rehearing, it discussed it focused in a bit more on what the county court talked about with the consent issue.
Well, I don't want to put words in your mouth, but my response to that argument was both prongs of the Strickland test are factual.
Sure.
Both prongs, whether there's been ineffective assistance and whether there's been prejudice.
Absolutely, and I hesitate, as a counsel for the appellee on a cert petition, to be dragged down to a third county court hearing. But if I had to, I would say that we've won, because When counsel's saying that there's some sort of burden to prove that this consent wasn't tainted somehow, well, that might be a standard that's applicable to motions to suppress. But what happened in the county court was an untimely motion for a 3.850. The burden in a 3.850 motion is well established. It's not on the state. It's on the defendant to say that there was deficient performance and prejudice in Strickland. And what the county court found and what the circuit court affirmed was that Ms. McDonald consented to this blood test, so there wasn't even deficient performance. Now, if there had been deficient performance, I think we'd still be at the position of saying, too late. You've got 2 years to discover all your legal arguments that you can bring. That's what the statute of limitations is for. And the cold hard truth about statutes of limitations is they're only good when someone has a good claim and they're bringing it too late. If someone has a bad claim, we don't need a statute of limitations. In this case, the person had a bad claim on the merits and it's untimely. And the circuit court considered all of this, especially when it considered the denial of a rehearing where it went through everything the county court looked at. So my only thing to add to the beginning of the argument is to look at this from the certiorari standard. Did the circuit court apply the correct law? Absolutely. Was there any manifest injustice? No. Her sentence of 2 months to probation was over almost 6 years ago. There could be no manifest injustice. So this case is utterly unworthy of this court's certiorari review. And with that, this court would, the state would ask that this court deny the petition.
What was it about? Not getting a second DUI conviction?
My thought is, yes, that progressively DUI convictions get worse the more you have, and so to attack the first one would make a sentence for the second one easier, and the record that we have doesn't discuss what stage the second DUI is in, whether it's been stayed pending this court's decision or something like that. There's just a mention that she was charged in 2005, July of 2005, with a second DUI and consulted her new counsel, who's her certiorari counsel, 3 months later, and that's when she found out this supposedly newly discovered fact, which was her new lawyer's opinion about what lawyer number one should have done. So if there's no further questions, I'll yield the balance of the time. Thank you.
One of the bases for the petition in this case is that the circuit court made a factual determination in this case, which is not the province of the circuit court. The circuit court, relying on tipsy coachman, said it wasn't timely because she knew, she and counsel knew, and it cites that in its opinion. That is an improper weighing of the fact that is not the province of the circuit court. And that's why on certiorari review it is appropriate to bring.
Why is that finding material if there are no new facts?
Because the county court did not make a finding.
Let's assume you're right, though, that the circuit court couldn't have made that finding. Why would that matter unless in the absence of an allegation of newly discovered evidence?
Because the circuit court affirmed the county court. The circuit court found apparently that the county court's determination was not correct, not correct as far as substantive, but found only that it was not qualified as timely because
wait just a minute.
She knew.
The circuit court found that the county court's determination
of the substantive issue because it said
was incorrect.
It had to have because it stated, I can affirm this under tipsy coachman even if it was entered for the wrong reasons.
That doesn't mean it
wasn't. That's not a finding, and you know it.
However, the circuit court specifically indicated that in its order. It didn't say notwithstanding. It specifically cited tipsy coachman and specifically stated that it had the authority to affirm it even if it was entered for the wrong reason.
That's like when people come here and we deny certiorari on the ground that the petitioner can't show irreparable injury. Someone says they must have agreed with us on the merits because they said there was no irreparable. Well, maybe we didn't agree with that either and just didn't feel the need to say so. I mean, how can you get to the conclusion that the judge?
Had the court not made that statement, I would agree with you that it would be the same as if this court denied certiorari based on failing to meet the standard, actually. But the court made that, it included that in its order.
Ms. Robbins, I'm sorry, Ms. Cohen.
Yes, sir.
Maybe even more to the point or less to the point, that leaves the county court's finding of consent unscathed.
Except that is not consistent with the law.
Let's assume the lawyer committed malpractice, and let's assume the county court made the wrong factual finding. My question is, what difference would that make?
Because that the question of consent, that would go back to whether or not the circuit court properly applied its proper standard in reviewing the decision of the county court, because the issue of consent is not just somebody signs on a dotted line consent, particularly.
So you don't think the circuit court could have just PCA'd this case?
No, sir, because the other issue is.
Counsel, of course it could have.
Well, it could have, but it would not have made it correct.
Counsel, I know what your practice is. What I'm telling you is that we hear these cases, dozens of these cases every week, and I suggest to you that had the circuit court PCA'd this case, trial court's factual, there was an evidentiary hearing in this case.
There was an evidentiary
Trial
hearing?
court's factual conclusions would have been unscathed, and because of that, the fact that the circuit court didn't address those conclusions doesn't make them any weaker than had the circuit court PCA'd them.
However, the county court made a determination that there was something indicating consent in the documents. However, again, that legally would not have been a valid conclusion based on the other evidence in the record and the fact that the state would have had to establish.
What I'm trying to suggest to you unsuccessfully is that a PCA would have meant the circuit court disagreed with you, and that's not a basis for certiorari jurisdiction.
However, if the circuit court disagreed, it's a little more complicated, I think, because you can file.
This case actually is very simple.
It really is.
And it's a loser.
It really is.
And I see I'm out of time, but just in closing, because we've gone all around and gone into some of the county court issues and everything, our position is the real issues before this court are the circuit court's review under an application of 3.850, that it made factual determinations that were not made by the county court, that based on that, a certiorari review by this court is appropriate, understanding the social implications and the other related matters, that this case is different factually. However, procedurally, it's appropriate for certiorari review based on the actions of the circuit court.
Thank you. Thank both of you for being here on a Friday morning. We appreciate it.
Thank you. And I appreciate your